So welcome, everyone. I'm Catherine Wilhelm, Executive Director of the U.S. Asia Law Institute, and this is our Asia Law Weekly program. So on to today's program, Lifting the Corporate Veil on China's State-Owned Enterprises. The role of state-owned enterprises, or SOEs, in global trade and development is a challenge to international law because international law wants to classify actors as public or private. And today's speaker, Professor Freya Baetens, has undertaken a detailed study that you can find at our website, which is grounded at least partly in her own legal practice, looking at how international tribunals make this public-private classification in three big areas: investor-state disputes, trade disputes, and human rights claims. And she finds that the legal test for being public or private really varies quite significantly across these subsectors of international law. Professor Baetens teaches public international law at the Pluricourts Center at Oslo University, and she is affiliated with the Europa Institute at Leiden University and has many other affiliations you can find in her full biography at our website. She's a member of the Brussels Bar, and she regularly acts as a counsel or expert in international and European disputes. And we have with us as well, to serve as an expert discussant and moderator in the Q&A, is Professor Robert House, who is the Lloyd C. Nelson Professor of International Law at NYU School of Law. He's a specialist in international trade law and has been a pioneer in applying international human rights to trade issues. In addition to writing extensively about the WTO, he writes about global governance and legal and political philosophy. So with that, I want to give the mic to Professor Baetens to make her opening remarks. And then after that, I'll turn it over to Professor House to make some comments and begin the questions. Professor Baetens.
Thank you very much, Catherine. First of all, I'd like to thank Catherine and Jose for inviting me, for Rob for commenting on my presentation. It's really a pleasure and an honor to be at NYU, at least virtually. I'm not sure whether in this for this audience I actually need to prove that my slides don't work, for starters. Oh yes, and why SOEs are important. But for those that need convincing, if you look at the Fortune Global 500, over 25% of listed companies are SOEs. And in 2019, for example, 6 of the highest ranking companies included the 3 Chinese SOEs and 1 Saudi company. SOEs own trillions of dollars of assets. They employ millions of people. And this is particularly relevant for China, which has 51,000 SOEs, and they're valued at over 30 trillion US dollars. They employ over 20 million people. But what is also important is that SOEs are often massively subsidized. So, for example, in one study, they found that between 1995 and 2005, subsidies to Chinese SOEs amounted to 151 billion US dollars. So I think nobody can deny that SOEs are increasingly prominent players in worldwide markets. But I think there's also a potential problem that some issues might arise that were not foreseen by rulemakers, both at a domestic and at the international level. So one question that I'm asking here is that SOEs, as they differ from private companies in terms of immunities, in terms of where their money comes from, in terms of responsibilities that they have, the question then is, do they offer states an ability to hide behind them or to benefit from them without complying with certain of their own international obligations? I think the very least we can say is that there's a lack of clarity whether international rules apply, and if so, which international rules apply. And one entity that has been complaining about this for quite some time is the European Union, or particularly the European Commission, that says that in the context of WTO reform, at least, that the growth and influence of SOEs in recent years is not matched with equivalent disciplines to capture market distorting behavior under the current rules. So what the EU at least wants, and that is often supported by the US, for example, as well, is that there has to be a clarification to determine whether a state-owned or state-controlled enterprise performs a government function or furthers a government policy, as well as how to assess whether a member, and in this case a WTO member, exercises meaningful control over the enterprise in question. Now, when we talk about SOEs, I would like to sort of make sure at the outset that we are talking about the same thing, and there is no general definition of what qualifies as an SOE. Some have said it's a commercial enterprise predominantly owned or controlled by the state or by state institutions, but that may or may not have separate legal personalities. Others have said that an SOE is a legal entity in which the state has full ownership and control, or has a controlling interest that enables it to take part in commercial activities separately from public administrative functions. And there's even a broader definition that defines SOEs as any non-financial company where the state exercises control regardless of the share of its ownership. Now, whatever their definition, SOEs test the boundaries of the fundamental principle that the law of international responsibility put forward, namely that the state is only responsible for its own conduct. SOEs are created by states as separate legal entities, but it's not always clear where the conduct of the SOE stops and that of the state begins. And that might have significant repercussions. If SOE acts would have been violations of international law, violations of the international obligations of the state, had they been committed by the state, then those affected by such acts may try to pierce this corporate veil and by doing so attribute those acts to the state, and then they may be able to obtain redress, whereas they may not be able to do so if they act before domestic courts against the SOE directly. But this is not merely an issue of international responsibility. This is also an issue, for example, with regard to the laws on immunity, with regard to the law of treaties, and with regard to the issue of standing, particularly in the context of human rights and investment law. Now, the rules on attribution, as often applied or often referred to by courts and tribunals, are those developed by the International Law Commission, but they are applied in a broader context than merely responsibility. And I will, as already announced, have a very brief look to take you through investment law, WTO law, and human rights law, and see what these dispute settlement mechanisms have done with these rules. So very briefly on the International Law Commission's articles, there's essentially three ways to attribute the conduct of any private actor, be it an SOE or another one, to the state. And the first one is if you can prove that the SOE is actually a conduct or is actually an organ of the state. If we look at these articles as developed by the ILC, it's very clear that there was no reference or no thought about state-owned enterprises in the commentaries on what is an organ of a state. So they talk about legislative, executive, judicial, or any other functions, whatever position the entity holds in the organization of the state, whether it's a central government organ or a territorial unit of the state, and anything with regards to that is an organ with regard to the international law, internal law of the state. I can already tell you that that is not how tribunals have seen it. They have classified some SOEs as Article 4 organs of the state. Another option is that SOEs would be seen as entities exercising elements of governmental authority. So that's the conduct of a person or entity which is not an organ of the state, but which is empowered by the law of the state to exercise elements of governmental authority. And then their acts are seen as acts of the state, provided that they're acting in that capacity in the particular instance. Again, looking at the commentaries, what were the ILC members thinking of? Well, for example, state-owned airlines with delegated powers relating to immigration control or quarantine. Or, for example, looking at the Iran-US Claims Tribunal, a foundation that was holding property for charitable purposes, including the identification of property for seizure. So that was, SOEs were kind of considered, but not to a large extent. The only place where they do pop up is in the ILC's work is the Article 8, which is conduct directed or controlled by a state, which is then considered conduct of the state. And there we see that the ILC referred to conduct of companies that are state-owned and controlled, but immediately adding that international law acknowledges the general separateness of corporate entities at the national level, except in those cases where the corporate veil is mere device or a vehicle for fraud or evasion. But that would require a particular, that you can establish a particular intent, which will often not be possible. Insofar as SOEs are considered to be separate, prima facie their conduct in carrying out their activities is not attributable. Again, that is not just the ILC saying that, that's also, for example, the Erroneous Claims Tribunal saying that when they were looking at a de facto seizure of property by an SOE, but without any evidence that the state had used its ownership interest to direct the company to seize this particular property. And so it's only when there's proof that the state is using its ownership interest in or control of a corporation specifically in order to achieve a particular result, that conduct will be attributed by the state. Now, that's the theory, and that's also the rules as codified more than 20 years ago. So the question is, does this, in light of SOEs increasing prominence, does this still suffice? Are we capturing the conduct that we wish to capture? And then I'd first like to take you to some investment law, where this is particularly important in two areas. The first one is to establish standing. And for attribution in relation to the question of standing, that is important because only private parties are in principle allowed to bring a claim. I will then also have a look at state responsibility, because there, if the corporate veil is lifted, the state can be held responsible for conduct that otherwise it would not be responsible for. So starting with standing, the idea is an investment arbitration that you have a claim by a foreign investor, a private party, against a state. So not in principle, not an interstate case. That is, for example, in the ICSID Convention, the references to a national of another contracting state bringing a case against a contracting state. So that has been interpreted, for example, in the CSOB case, where the fact that a state was the majority shareholder in a claimant and thus had absolute control was not considered a problem for this particular claimant, this particular SOE, to actually bring the case. In another case, Beijing Urban Construction, the claimant was a publicly funded and state-owned entity established by China that was working on an airport in Yemen. And again, the tribunal said, regardless of the fact that it was owned by the Chinese state, regardless of the practices of this Chinese state with regard to its SOEs, what was important, or what they looked at, was how it performed its work. And its work on the airport in Yemen was considered that of a commercial contractor, so the claim could go ahead. And what you often see is that these tribunals use an RCWA analogy to establish or deny standing, even though the RCWA, the articles on state responsibility or responsibility for internationally wrongful acts, which are the ILC articles, they are used even in situations outside of the international responsibility context. Sometimes you find a lex specialis. So, for example, the Energy Charter Treaty does not differentiate between state-owned and privately owned entities, so there you don't have a problem. Moving then to state responsibility in this context, an arbitral tribunal may not need to address the point because, again, there are some treaties by BITs, also the ECT, that provide a lex specialis. So again, the Energy Charter Treaty says that no contracting party shall encourage or require a state enterprise to conduct its activities in its area in a manner inconsistent with the treaty. That was also, for example, at play in a case called Bosch, where the applicable BIT obligated each party to ensure that state enterprises act in conformity with the provisions of the BIT, wherever such enterprises exercise any regulatory, administrative, or other governmental authority that was delegated to them. So what happened was that you create a positive obligation on the part of the state, even if the state is not fully in control of the SOE, but a positive obligation to prevent certain conduct, which, if it were the state's conduct, would give rise to a separate claim. Now, most treaties, most BITs do not have a lex specialis in this regard, so then you fall back on these ILC articles on state responsibility. And then there's actually 3 principles that impose separate standards for attribution of conduct. As we already said before, you can look at whether it's a state organ, whether it is an entity that exercises governmental authority, or whether there's some form of direction of control. And the first case where this really was important was Maffesini, the Maffesini versus Spain case, where the tribunal actually did a double-pronged test. On the one hand, they looked at the structural context. So, for example, state ownership, state control, directly or indirectly, they said gives a rebuttable presumption that it is a state entity, that is, SOE is a state entity. But that is counteracted by a functional test, which looks to the functions or the control over a particular entity. And what then happened is, in this case, as in many others, that you have to start splitting up the acts of the entity and look at each act individually. So if there's 5 acts that are complained about, it could well be that 3 of them are attributable and 2 are not. And that kind of approach, they have this functional and structural test, was followed, for example, in a case Flamingo versus Poland, which was about the management of a state airport, and where the supervision and control of the Ministry of Transport was seen as structural and very substantial. But what you then see is that in other cases, such as Star versus Latvia, which was also about the management or the part of the construction of a state airport, the facts were very similar. But the tribunal came to the opposite conclusion. So where there was in Flamingo versus Poland, the tribunal thought, oh, well, this is not merely an entity exercising governmental authority. This is really a de facto state organ, which means that everything they do can be attributed. In Star versus Latvia, you get the opposite conclusion where they say, oh, no, this is not a state organ. We have to look at acts that are really directed or controlled, and they arrive at a much higher bar. Outside the context of airports, there have been cases with regard to natural resources. Kardasopoulos versus Georgia, for example, dealt with 2 state-owned oil companies, where the tribunal held that the relationship between the companies and the state bore all the hallmarks of attribution. And quite typical, actually, and other tribunals, for example, Nikom versus Latvia, have done the same. They start by using terminology presented by the ILC, but then they don't specify which article they are working with. So in the end, they might find attribution, but they don't really say, okay, well, this is a de facto state organ, or this is directed or controlled. It all becomes a bit of a muddle. Some have tried to apply not only, some tribunals have tried to apply only the functional test and not the structural test. So not looking so much or at all at state ownership, but looking only at what the company actually does. And for example, in Jan de Nul versus Egypt, the management and operation of the Suez Canal was seen as a public activity. But in the end, it was not found to be attributable because there was the SOE had a separate juridical personality and a mandate to also perform acts of commercial nature. So what I want to to give you the ideas how tribunals, how it's completely or virtually impossible to predict how a tribunal will apply this test, which I think just that is already a very undesirable situation. And this affects a wide range of activities. So, for example, there have been a number of cases where universities were assessed as SOEs because they enter into contracts, but at the same time, they have essential governmental functions, but all their money most of their money comes from the state. So this is a very wide-ranging problem. So in general, in investment law, there has been a quite stringent approach. So not far from all investment tribunals that were confronted with SOEs have actually found that their contract was attributable, but the legal basis on which they did so is often was often murky, to say the least. I want to move on to the WTO. The WTO has some specific exceptions from the rules on state responsibility, but of course, there's no issue with regard to standing because you cannot have private standing. But with regard to attribution, it's largely silent except some specific provisions that deal with SOEs or, for example, Article 17.1a of the GATT that deals with state trading enterprises. And there it is said that each contracting party undertakes that if it establishes or maintains a state enterprise or grants to any enterprise exclusive or special privileges, that that enterprise then has to act in a manner consistent with the general principles of non-discriminatory treatment. This was not a very frequently applied problem in the context of SOEs. For example, in Korea, beef, there was a monopoly on the import of beef that was considered such a privilege. A provision that has been far more frequently applied are the provisions in the agreement on subsidies and countervailing measures. And that is already, or the problem already arises with the definition of subsidies, saying that subsidies are financial contributions by a government or any public body where a government makes payments to a funding mechanism or entrusts or directs a private body to carry out one or more of the type of functions which would normally be vested in the government. That has been more frequently applied in WTO case law. I will not go through all cases. I'll just give you one example, which is the US anti-dumping and countervailing duties case, where the question was whether a wholly or majority-owned enterprise, government-owned enterprise that produces and sells goods and services, whether that is a public or private body. And initially, the panel thought, no, you can't move from one to the other. The same entity cannot change character. It's either governmental or commercial. But the appellate body disagreed. And in terms that are actually quite reminiscent of investment law, said that the conduct of governments and public bodies falls within the scope of the agreement. There's a commonality between the two, and that commonality lies in the performance of governmental functions, which again means that for each measure, you have to start looking whether the SOE had or was exercising a government function. That also has been adopted in subsequent reports. And elements such as ownership or the power to appoint or nominate directors, they do create some, indicators of control, but they are not determinative. So essentially, the WTO appellate body will look at the actual acts and will also refer again to the ILC work. But of course, to conclude on the WTO, the fact that an SOE is not a public body within the meaning of the SCM agreement does not mean that its conduct can never be attributed, or even less so that it's not relevant. So the appellate body has also looked at concepts of entrustment, of direction of a private body on other occasions, and thereby they've given to the term direction quite a broad interpretation, broader than command, because they see that there's more subtle ways to direct an SOE than directly commanding it, and that might well lead to serious price distortions in the market. Now, the last field that I would like to address is human rights. Originally, a bit like in investment law, the focus was very much on standing issues. So for the European Court of Human Rights, the court may receive applications from any person, non-governmental organization or group of individuals, but it cannot, for that particular type of application, you either have an interstate case or an individual state case, and the rules can be quite different. The American Convention on Human Rights also states that legal petitions can be lodged with the Commission by any person or group of persons or any non-governmental entity legally recognized in one or more member states. And the idea behind this is that to prevent the contracting party to act both as an applicant and a respondent, worst case scenario in the same case. And there's two alternative criteria that have been used to characterize an entity as a governmental organization. And if you are characterized as a governmental organization, you can be deprived of legal standing to bring an application against the state. So first, the exercise of governmental powers, and second, the operation of a public service under government control. And in this context, the court, and I'm now talking about the European Court, held that action must be taken of its legal account must be taken of this entity's legal status, and where appropriate, the rights that status gives us, the nature of the activity it carries out, and the context in which it is carried out. So what that means is that in terms of standing, the rules are fairly similar. And gradually, the human rights courts have also focused more on SOE attribution as there were more SOEs and as their conduct became more controversial in certain cases. And I'll just give you, in terms of the seminal case in the European Court of Human Rights was Alicit, where the Grand Chamber of the European Court of Human Rights attempted to spell out the criteria to determine whether the state was indeed responsible for debts of what is a separate legal entity. So they looked at the legal status of the company, the nature of its activity, the context of the operation, institutional independence, operational independence, and whether the state was directly responsible for the company's financial difficulties. Because a lot of these cases were actually related to people who were owed money by the SOE had to pay money. For example, there was a case where somebody had been working for an SOE in the cleanup of Chernobyl. This is the Mikhailenki case, and they were actually never paid, and domestic courts had found in their favor, but the SOE had never paid. And then the question was, is the state obliged to pay? There have been a number of other cases. For example, in Khadija Ismailova case, there was this lady said that her right to private life had been breached by the publication of stories by 3 newspapers. These newspapers were state-owned or state-controlled. They were not even always owned by the state. Sometimes they were owned by senior officials in the ruling party. And then the question was, is the state responsible for this? And in response, the European Court observed that it could not establish beyond reasonable doubt that the conduct of these entities was attributable to the state, but the state had a positive obligation to prevent these companies from acting in that way. I have already mentioned this as a lex specialis within investment law, but this is particularly prevalent in human rights law, that even if no attribution can be found because the rules are just not very suited, the rules as they stand are not very suitable to find or to examine behavior of SOEs, courts will get around that by looking at the state's obligations to prevent certain actions of companies. And then they don't have to look at attribution anymore. Now, in conclusion, brief conclusion, I think we can say that SOEs push the boundaries of the international rules with regard to conduct across various fields of law, including investment, WTO, and human rights law, and most notably with regard to standing and the establishment of state responsibility. There is an increasing number of these cases, probably because there are more SOEs and they are using dispute settlement mechanisms, or people are using dispute settlement mechanisms against them. But the existing rules were not drafted with SOEs in mind. So you leave it up to courts and tribunals to fill in the gaps. And as a result, because there's so little guidance in the law, the jurisprudence is inconsistent, even within the same subfield, let alone across different fields. Something that I addressed in the paper, but not in the presentation, is that there's some evidence that new treaties and treaties currently under negotiation are more tailored, or at least drafters try to tailor them more towards a specific situation of SOEs. And I'm thinking, for example, about CETA between the EU and Canada, and the TPP, the Trans-Pacific Partnership. But I still think that a general revisit of attribution rules would seem desirable to prevent such wide inconsistency and unpredictability. Thank you.
So, Professor,
should I now field some questions?
So Professor House, if you would like to, you could do a number of things, respond first to some of these points if you wish to, or go directly to questions. It's entirely up to you.
So why don't I make a couple of observations on this very rich and illuminating presentation. The first is that I completely agree that in the context of investment law and investor-state arbitration, the reasoning of tribunals on attribution, here we're not talking about the standing question, but the attribution to the state of internationally wrongful conduct has been murky. That seems to me to be the right word. And what strikes me in looking at many of these cases is that perhaps for reasons unconnected to the problem of attribution, investment arbitrators like corporate veils. Corporate veils perform a number of useful functions especially from an investor's point of view, but also from an arbitrator's point of view, because you get rich when you hear cases and don't get rich when you don't, since the arbitrators are paid by the parties and by the case an hour and so on. We could look at other contexts like Dutch sandwiches, where the corporate veil is basically used to treaty shop to obtain for a business entity coverage under an investment treaty where the underlying economic interests are not really connected to either party of the treaty, but the treaty is in some way favorable in terms of some project that the investor wants to do. So there's a bias in favor of the corporate veil that seems to me to make investment arbitrators in this very different context actually want to take very seriously evidence of formal independence from the state, even if it's just evidenced by a separate juridical personality, whereas someone like me, a good social democrat, would say that's really largely irrelevant. The big truth staring you into the face is that states use state enterprises because they think they're helpful to the promotion of public policies of one sort or another. And the capitalists think that the provision of goods and services to consumers is not something that's the business of government. And therefore, the more that a state enterprise appears to be doing that, the less it's considered to be governmental. But from a social democratic point of view, there may be many situations where we prefer public rather than private enterprise as a means of operating the productive economy and of providing goods and services to the public. And so I think that the taste for the corporate veil and the taste for a view that suggests that commercial activity understood as being directly involved in the productive economy is not appropriate for the state. That capitalist prejudice drives the investment tribunals often to Article 5 because evidence of separate formal juridical personality, plus the prejudice that if the enterprise is largely engaged in commercial activity, it's not an organ of the state or an instrument of the state, then you have to look elsewhere to find attribution, because if you don't find to find attribution. And so they often find attribution either without specifying which ILC article or through Article 5 or Article 8, whereas I, as a social democrat, would say it's quite plausible in many of these cases to characterize the enterprise as an organ of the state, and I would take less seriously the a separate corporate juridical identity or personality. If in fact, the state is, as it typically is, using these enterprises to further goals or objectives of a public nature, and competing in private markets or delivering goods and services in the marketplace can well be a governmental objective for various good reasons, at least if you take a social democratic perspective on it. And I would add, and I think this is quite consistent, Freya, with your analysis, that there's nothing in the ILC text that suggests that a state enterprise could not be considered an organ. The concept of organ is very broad and requires a case-by-case appreciation of the legal and operational connections between either a natural person or another entity and the quote-unquote state. So that's kind of my 2 cents worth. I also think that and this goes to something else you pointed out, this issue of attribution has become, in the state enterprises context, very much entangled with the notion that somehow state enterprises are a threat to competitive markets, and we need new positive obligations somehow to discipline their anti-competitive practices. And in a paper I think you've seen and a few people have seen, which is I'm in the process of developing, I make an argument that one should completely disentangle these 2 questions. The question of whether the jurisprudence under existing secondary rules is sufficient to properly make the state responsible for conduct that is inconsistent with existing primary obligations, and whether we want to look at state enterprises differently from the point of view of primary obligations. And the EU, the European Commission in particular, I think is trying to bootstrap all of that concern about the jurisprudence over public body and in the WTO, the sense that attribution is broken, because in many instances where in fact the state ought to be responsible for the conduct, it isn't viewed as responsible, into a very different and, to my mind, insidious agenda, which would be to create new primary obligations that hold state enterprises to antitrust type standards with respect to quote unquote competitive neutrality. And that, to my mind, is insidious, first of all, because there is no antitrust code in the WTO. And so it would be a way of entrenching a kind of pro-capitalist bias against state enterprises, because state enterprises, in effect, would be held to competition law type standards that non-state enterprises are not being, held to. I mean, if you're really worried about distortion of competition, start with Google and Amazon. That's where I would start, because, they use and abuse market power at a level that almost any state enterprise could only dream about doing. And so, what the EU is up to here is really to say, we will constrain state enterprises from engaging in anti-competitive practices in the WTO. We want to do that, but at the same time, as the WTO doesn't have any rules to constrain Google or Amazon or Apple, et cetera, et cetera, et cetera. And to my mind, that's insidious. It's fundamentally unfair. It also distorts the reality that the danger to competitive markets today is much more from the tech giants than it is from state enterprises. And the second dimension is that developing countries rejected resoundingly the EU's desire to bring investment protection into the WTO. And this is a hidden or indirect way of trying to do so, because what does this idea of competitive neutrality mean? It means that that state enterprises are compared to private firms, and it introduces, in a way, a kind of a non-discrimination obligation with respect to firms or enterprises, and that doesn't exist in the WTO so far. To a very limited extent, with respect to one modality in trade and services, commercial presence, there's some overlap, but there, individual WTO members have to make their own commitments in order for the non-discrimination, the national treatment obligation, to kick in. But otherwise, it's discrimination with respect to goods and services, not enterprises. Once you get into a charter that requires some kind of competitive parity between enterprises, you're going in by the back door to introduce a form of discipline that most WTO members, and certainly almost all developing, not all, a large number of developing country members, have stated emphatically that they do not want negotiated in the WTO. Anyhow, I've spoken for way too long. There are quite a few questions, and so why don't I start taking some of them, and when you wrap up, Freya, maybe if you want to in any way comment on what I've said, that would be fine too. Okay, from Dr. Seiko. Thank you for your talk. Are you aware of cases in which an SOE, et cetera, has been denied standing in investor-state arbitration? And if so, what was the tribunal's reasoning?
Sorry, Rob. I was just. I'm very sorry, but could you repeat the question? Because I was taking notes on what you were saying before, but the last question I missed.
No, so are you aware of cases in which an SOE, et cetera, has been denied standing in investor-state arbitration? And if so, what is the reasoning?
So, am I also allowed to respond to what you said first?
If you like, if you prefer, yeah. Yes.
So I agree with what you said, that the idea of lifting the corporate veil is a much broader issue than merely in the context of SOEs. And I would actually say that your impression is that tribunals have frequently because they're paid by the hour, have frequently allowed the sort of treaty shopping through raising corporate veils. I think claimants have frequently tried, tribunals have frequently denied it. So one of the cases, the typical cases, is the Philip Morris versus Australia case, where Philip Morris tried to restructure and to go via Hong Kong, and it just doesn't work. Tribunals don't buy into it. And they shut it down at jurisdiction level.
In Philip Morris, it was very narrow, in the sense that Philip Morris was held to be creating that structure in anticipation of litigation. I'm referring to the more general Dutch sandwich type situation, where the corporate artifice is created before any particular dispute is on the horizon, but simply to gain advantage of a treaty where
Yeah.
the state in question doesn't have any real connection to substantial business activity.
Yeah,
Sorry,
I mean, it's
just
done
wanted
for
to-
other reasons than to get advantage from investment treaties. I think it's mostly done for tax reasons. But what I meant to say is that once there is a dispute, if you then change in order to bring a case, a tribunal's not going to buy into it.
That's
But
true.
in any case, so I looked at a more narrow kind of lifting the veil, not so much corporate veil in terms of structures of different private companies. I only looked at it for the purpose of standing of SOEs or attributability of conduct of SOEs to the state. I try actively to keep sort of political opinions or at least mine out of the research. So I'm not in favor or against SOEs. I think they can be terribly useful vehicles. I can fully well see why states want to use SOEs. I think they can be more effective, particularly when a state wants to engage in commercial conduct. But my main focus is if a state, maybe not intentionally, but if it just happens that an SOE is engaging in, say, violations of international human rights law, international labor law, international investment law, international environmental law, that is fine because these international treaties don't apply to private entities, but they would apply to the state if the state was engaging in exactly the same behavior as the SOE. Then I think the risk is, or then at least the law should provide for lifting the corporate veil to prevent that kind of circumventing of obligations of the state. That's the only or sort of my only reason, in addition to a more sort of procedural one, and that is I think the law should be predictable. I think any SOE, any state should know where they stand, and they can take it into account. I agree with you that the ILC did not mention anything, or the commentaries don't mention anything, the discussions don't mention anything that would prevent an SOE from being a de facto state organ. I think it's simply not been considered properly. And I actually asked a number of ILC members who were serving on the former ILC members who were serving on the ILC when these issues were discussed. And I invariably got very surprised looks saying, SOEs, why are SOEs important? And then I start explaining, well, again, the 6 biggest companies in the Fortune Global 500 list, out of those 6, 4, as in 2/3 are SOEs. These are giant companies. I mean, Google is not in the top 6, Amazon is not in the top 6, but Chinese SOEs are. A Saudi SOE is. So I think that is just makes it worth to look at it. Whether it's a threat to a competitive market, again, it can be. Maybe not, maybe yes, but I think the rules should at least make it more clear, also for the states involved, also for the benefit of the states that have SOEs, that they need to know if they funnel money into, or if they give money to an SOE, if they put money into an SOE, particularly with the purpose of this SOE handing that out further, to what extent can this be a subsidy or not? And then they can, adjust their actions. But I agree with you, the WTO does not cater for this, and I'm not saying anything the EU says should be accepted in this regard. Of course,
these were just my own thoughts. They weren't triggered. I mean, they were triggered by the issues you raised, but they weren't intended as a response to your specific positions. Just to be clear, it was a way of advancing the discussion. I mean, and in fact, I'm in favor of a very broad attribution approach, which would be a presumption of responsibility where there's any significant government involvement. But then the question is, what are the primary obligations? And so at one point you talked about the issue of causative obligations, but didn't have time to develop it. So I guess what I was only suggesting is that I think that along the lines that you may be intimating, we could probably solve the attribution issue within the existing framework of primary obligations by taking a less formalistic approach to the way in which government is involved in state enterprises, regardless of their formal structure. And I think that has to be right.
And just to respond to the specific question, am I aware of any cases where SOEs have been denied standing? No, not specifically standing, because there haven't been that many either. There have been very many cases where the conduct of the SOE was not attributed. So on the whole, if in doubt, the corporate veil stands, I think, with regard to SOEs, which means that the SOE can bring a claim, can act as a claimant, but which also means that the state escapes any responsibility for the conduct of the SOE. But that is an extremely, extremely broad generalization of what tribunals and courts have actually done.
And for arbitrators who are profit maximizing actors, of course, that's what really counts, because if you don't find a way of granting standing, you don't get your, several $100,000 per arbitration fee, and some of them make over $1 million per case. I mean, it's quite scandalous. I think Yves Fortier in one case billed 10 times the annual, just one case, 10 times the annual salary of a U.S. federal judge.
Well, I really disagree with that. I'm not defending arbitrators in general, but I think most of them, like most judges, are honestly trying to do a good job and will not find jurisdiction if there is no jurisdiction. They might tend towards giving someone the right to their day in court and then shutting them down when it actually comes to the merits, because they feel that there might be something, but if the evidence isn't there, they won't grant any damages. But I don't, and of course you can find one or two arbitrators who have, not behaved according to that standard. Yeah. But I would say on the whole, I do think these people are trying to be as professional as any judge or any lawmaker or anyone else.
Okay, next question. To what extent is it considered legally relevant that an SOE performs both a social and a commercial function?
Sorry, what social and commercial function, whether that's
This is from Kenneth Wasserman. To what extent is it considered legally relevant that an SOE performs both a social and a commercial function?
Well, that would depend how you regard the SOE. If you say it's a state organ, it's not relevant. But if you say the conduct is attributable on the basis of the exercise of governmental activity with for a governmental purpose, then suddenly it does become relevant, because in that context, the commercial conduct could not be attributed to the government, whereas the social conduct, the public interest conduct can be attributed. When you look merely at directional control, then it just very much depends on the specific act and the specific purpose that the government try to achieve.
Okay, so next question from Peter Neumann. Are you aware of any court decisions or arbitral awards in which the influence of the Communist Party organization in a Chinese company, including both SOEs and nominally private companies, has been identified as a material factor in characterizing it as a public entity or as engaging in a public function?
Well, as I just said, in the one case where the tribunal actually does discuss it, and I have to rummage a bit because I now forgot, but I mentioned it in the context of the Chinese cases in investment law. The tribunal actually said, no, we don't look at the conduct of the Communist Party. We only look at the function of the case. It was the one with the Yemen airport, but I'm trying to remember what the name of the company, actually, Beijing Urban Construction. So that's the only case where the Communist Party was indirectly discussed, and it was discussed in order to dismiss it or to dismiss its influence as such, because they looked very much at the performance of the work as a commercial contractor and not as an agent of China. I do, and that is one of my complaints about this jurisprudence. But I also think tribunals can't do anything else, because they are bound by the terms of the treaties. So the problem is with the states who draft these treaties and not with the tribunals who have to somehow, invent the law as they go, because they're not provided with the tools to decide these cases. So I see where the question comes from, and I agree that often the law is not only running after the facts, it's completely, to some extent, disregarding the facts.
I'll just add my own response to Mr. Neumann. In the second AD-CBD case, which interpreted public body, I believe the appellate body did say that it was legitimate to take into account the particular Chinese political and governance context in making a determination of whether an entity is a public body. I can't recall whether there was an exact reference to the Communist Party, but it was a reference to a document that had been produced within the Commerce Department about how all of these, ties and networks actually operate in China. So I sense the appellate body is saying that this is something, yes, that could be taken into account by a domestic agency in making a determination under the public body, provision in the SCM agreement. So we have another question, Ira Belkin. Do you agree that one of the reasons China is perceived to be non-compliant with the WTO regime is because of its heavy use of SOEs and subsidies in ways that are beyond the effective regulation by the WTO, or is this narrative unsupported by empirical evidence?
I would agree that that is definitely the perception and the main sort of complaint of the EU and to some extent the US as well. Whether that is in terms of empirical evidence, I think that has not been conclusively demonstrated, as in you will find studies that go both directions.
And I would add, I don't know, Mr. Belkin, if you looked at an article by Professor Mark Wu called China Inc. His study, is at a certain level empirical. There's an empirical level that it's very hard to get to, and this relates, I think, to, one of the elements of this set of complaints, which is lack of transparency in the way in which private and governmental and party actors connect to each other. But the Wu study, China Inc., is very important in understanding how these connections operate, so as maybe not intentionally, but in practice, to frustrate the ability to really enforce WTO disciplines that were not, designed, to deal with these kinds of informal network type relationships where governments or the state is influencing, market behavior, but not really through the mechanisms. State enterprises can be transparent, so it's not just state enterprises as such. And I think Wu makes this very clear. It's that there are many ways in which the party and the state can affect transactions in the marketplace, and their ability to do so is almost kind of legally and structurally unlimited, given the way the communist system works. But Wu, who is now in the USTR, by the way, to my mind, articulates this with brilliant clarity. Then we have Another question from Mr. Neumann. Oh no, that's the previous one. He's just thanking you for your answer. And so Mr. Belkin is saying, if this perception is accurate, how should China's trading partners, WTO members, address the challenge?
I think, first of all, by recognizing how important SOEs are, and to some extent to try to anticipate these cases by drafting treaties differently. I'm not saying that there should be necessarily attribution for everything an SOE does, but at least decide in advance what you find as states, what you find acceptable in terms of rules of attribution, in terms of also who can bring claims, in terms of what is a subsidy, or what does it mean to give funding to an SOE. I do think there is scope for for market distorting behavior, but again, don't just not mention that in a treaty. Devise rules that set a framework for assessing whether there's market distorting behavior or not. And that is an initiative I think that China could take as well. It would be beneficial to China, if only to prevent disputes in the future.
Okay, well, I think that exhausts, just let me check. Maybe there is another, yes, here. No, I think that exhausts of the questions. So there's another clear opportunity to jump in here if somebody wants to. I gather are we ending at
trying to jump in?
Yeah.
Professor House, I have a couple of questions that have been emailed to me by Jose Alvarez, who was unable to be with us today. So I'd like to put those out on the table, if I may.
Sounds good.
Okay. So following directly on this discussion of the role of the Chinese SOEs, he's asking whether, Professor Baetens, whether you see them in any way as unique, so that a search for generally applicable attribution rules is fundamentally the wrong way to think about solving the Chinese SOE problem. So just to rephrase this a little, the phrasing here, maybe I haven't articulated it clearly, is whether on the one hand, Chinese SOEs are unique in some ways, or whether on the other hand, the right approach is to search for generally applicable attribution rules.
I would say that there should be generally applicable rules. The Chinese SOE situation is perhaps unique in the sense that there's so many, and that we're talking about such an amount of assets. But in essence, whether you talk about a small SOE or an enormously large one who features among the top companies in the world, it shouldn't, for the rules of attribution, shouldn't make a difference. It makes the problem particularly acute for China, and it makes China the focus of everyone who wants to do something about the power of SOEs and the ability to circumvent international rules if you're a state with SOEs. But I don't think that there's something unique about China. I mean, I wouldn't accuse Chinese SOEs of being particularly devious or something like that, not at all. And I as I said before, I think that what is important is that we have a stable and predictable mechanism, and that would apply to all SOEs, Chinese and other SOEs. I don't know whether it would be possible to have rules across the three fields that I discussed. Maybe there is scope for doing things differently in human rights law, in investment law, and in trade law. Although I think we shouldn't just assume because these are different fields of law that they should have different rules necessarily. But if a good argument can be made, I think it would be, I could envisage with different rules within different fields. And there always remains the possibility to have in a treaty to have slightly different rules, like the Energy Charter Treaty has slightly different rules from most bilateral investment treaties, which is fine as long as you articulate these rules. And again, as long as investment tribunals or other tribunals or courts aren't supposed to make it up as they go, because there simply is no guidance for them.
Mm. So another question that he raises has to do with the Inter-American and European human rights courts. And you indicate that they take somewhat different positions on making states accountable for violations of their SOEs, and asks, do you have any idea why that is? Is it that the court thinks that businesses should be liable for human rights violations in the first place? And also, if true, is there something wrong with somewhat different regional conclusions, perhaps based on the different types of relationships between state power and SOEs in different regions?
So is it different, a bit different in Inter-American and European Court of Human Rights? Yes, they focus more. I mean, investment tribunals do that to some extent, to look at, well, if the state is not directly responsible for the act, they are responsible for the fact that they did not prevent the act. So a positive obligation, which is separate from really attributing the conduct. That is something you see a lot more. Essentially, virtually all cases before the Inter-American Court of Human Rights, as soon as it says an SOE, the court accepts that the state is responsible. So I think maybe human rights courts are more willing to make states accountable. But of course, it's always hard to speculate about intention. Whether you can derive from that businesses should be liable for human rights violations. Well, yes, I think they should. But I think in the first place, these disputes should be solved by domestic courts. But I also think if that is not possible, domestic courts are under huge pressure some domestic courts are under huge pressure to agree with whatever the state and its SOEs has done. So I think it's very good that there is an international option, not, as the preferred one, but just as a sort of a safety net. Whether there should be different regional conclusions, yes, but I think it should be reasoned, not just like, we're in Latin America, we do things differently here. I do think that is enough of a reason. And I think I would also not say that simply because a government is a developing country government, that for some reason it's less well organized or it should not be held responsible for what its SOEs do. In the end, if the act of any government is to set up an SOE, they have the same obligations and the same rights as everybody else with regard to that SOE under international law. So I think it's a contract is just as binding no matter who you are.
Mm-hmm. Okay. And the last question from Jose is that you rely on the Articles of State Responsibility, but can the ILC's Articles of IO Responsibility be helpful? So these allow piercing the IO veil when states circumvent their own obligations by using the veil of IOs. So they also pin the blame on states when these aid and abet human rights violations by SOEs. Should these concepts be incorporated into the attribution rules on SOEs in all or some of these regimes?
That is a fantastically interesting question. It's an exercise that I have not conducted for this paper, but it certainly bears thinking about. I think the articles on responsibility of international organizations, I think they have been less frequently applied. So it's not that there's a body of jurisprudence that you can look at, particularly with regard to the responsibility of states acting as part of the organization and sort of passing on the buck to the organization. I think there's very little has been done with that. But I think if states were to draft a treaty and were to be thinking about attribution, this would be a very good source to get ideas on in which case, if the obligation had been the state's obligation rather than the international organization's obligation, shouldn't the state just be held responsible in a more straightforward way? I think that's definitely something worth thinking about. Whether it will get you a lot further, I'm not entirely convinced of that, but that's also because there's just a lack of practice, probably.
Okay. So if I may, I'd like to add a question of my own. I wonder whether we should be taking a step back and viewing the situation from a somewhat, higher level. I was interested in what Professor House was saying about his view of it as a social democrat, in particular, in that it strikes me that the underlying issue here is a sort of I'll use carefully the word prejudice or pre-existing notion on the part of the rule makers and also the tribunals about how the world works, and about what is the proper sphere of government and what is governmental. I mean, time and again in your paper, you talk about this concept of what is a governmental function versus what is a commercial function. And I know that underlies a lot of international transactional, even in domestic courts, a lot of cases, state responsibility and whether something is, whether a state is exempt or not. The question of what is governmental and what is commercial is a very contingent question, contingent on the time, the era in which the question is being raised, and also in what society the question is being raised. And so to what extent do we need to reevaluate some of those assumptions, some of those presumptions about where lines are drawn, because they influence the rules sort of down the road as applied? So what I'm hearing you advocate for, Professor Baetens, is that there should be clearer rules of the road so that tribunals are not sort of making it up on the fly. But what I'm asking is whether we should step back further and just ask about what are the underlying assumptions behind those rules, about what is the default set of arrangements between government and society, between governments and commercial operators. Why do we assume that, an airport perhaps is a natural governmental function, but an airline perhaps is not so much, and a chain of noodle shops is definitely not a governmental function, when in fact in some societies there may be a reason for the state to consider everything potentially within its purview. And and there hasn't been, for example, in China, this traditional separation between private and public. This is just not inherently an element that you see in Chinese law. So if we go back to sort of first principles and question our own assumptions, can we perhaps start to revisit some of these rules in a more consistent way?
Yes, I think absolutely. I think that is something that we all should do regularly. I mean, in most universities, at least in continental Europe, you've got a public law department and a private law department, and these professors very rarely do not really talk to each other. So I don't know whether at NYU you have a similar structure, but so is there a certain prejudice? Yes, I think it's impossible to look at the law and not work from your own conceptions that were probably instilled in you when you were a young law student. I think government lawyers think when they draft treaties think the same way, and that's why I think that, for example, most treaties should have or should allow for the possibility that every 10 years or every 20 years, they are really properly revisited to see, does this really still answer to our needs, to what we want to achieve as governments? I also think there's huge differences between governments. As you gave the example of China, where, for example, a chain of noodle shops might be considered a governmental function. I also think that this is not a new issue. We've been, you can look at Roman law struggling with the same issue as well. So this has been around for at least 2000 years, and I'm looking at it with a very Western set of glasses by going to Roman law. I'm aware of that. So I think also it would be very good to think a bit less Western focused in how we draft these treaties. But even if you look at treaties between developing countries, you see that the same concepts are just adopted. And, I see developing countries as having full agency. So I wouldn't say, okay, they do it because they don't dare to do otherwise. I am assuming that they make an advantages and disadvantages comparison, and that they still think there's some kind of advantage to using these concepts. But I would indeed say that's not necessary. We don't have to do it along those lines, and we should better revisit these rules. I do not think it's up to a court or tribunal to do that on an individual case basis, but I do think it's up to states to think about that, and to particularly treaties that are in force for decades or possibly forever. It would solve, for example, the issue of states that suddenly withdraw from treaties and they blow up all bridges. Maybe if we would have a more sort of a regular modification approach it would keep more states on board. And the only question is then, if you have particular differences at the domestic level, to what extent can you translate that in a treaty, particularly with multilateral treaties, which I think, they have to always go for the lowest common denominator, and that might be not what each state wants.
Right. Thank you for that. And to ask another related question, when you grouped the responses or the approaches of the different tribunals across the 3 different fields of law that you were looking at, did you see any kind of a logic or pattern emerging in which you could see that tribunals in one area of practice, for example, in the WTO cases, were trying, by their approach to this public-private definition and the tests that they were creating, that they were trying to accomplish something in particular, that they were leaning in a certain direction and, in a sense, perhaps putting a thumb on the scale to make it harder or easier to determine public-private status, as opposed to the courts of human rights. And I think I heard you saying something that would indicate that the courts of human rights might be trying to make it easier to find the public connection in order to be able to accomplish the goal of holding a state responsible, where a company might not have the wherewithal to make the compensation that was being sought to provide justice in that case. Do we see this kind of a logic behind it, so that in human rights cases there might be more effort made to find a public agency, whereas in WTO or in the international tribunals, more of a effort against that, an attempt not to find that?
Yeah, I would say in investment law that some tribunals have gone out of their way to avoid finding attribution, because that would have helped them to avoid finding responsibility of the state. My personal guess might also be, and I'm formulating this deliberately as a guess rather than as an empirical finding, is that investment law has been so much under fire recently that investment tribunals will really look at anything or grasp at any straw in order to avoid finding yet another state guilty of something. And often, or not often, but sometimes you see that something really went seriously wrong, but if you can pin it on the SOE as a private company, you can leave the state out of it. And I think in human rights courts really always have had, I mean, everybody, well, not everybody perhaps, but most people like human rights. It's much more positively thought about, even if they do, adjudicate cases that might mean that states lose. Still, human rights is sort of has a much more positive percent. The public thinks more positively about, with the exception of cases where terrorists are tried, perhaps. But in general, the public view is much more positive of human rights courts. What I think also counts is that you have in the WTO, for example, you have the appellate body, and panels might go in all directions. But once the
not anymore, by the way, not anymore. The appellate
not
body
anymore. You have yes, correct. But I heard some rumors that there might be a solution in the make for that. But I will, to be correct, I will put it in the past tense. So in the WTO, you had the appellate body who could then set a precedent that was usually quite well followed by panels. Because you have a more hierarchical system, you have one treaty that applies to a multitude of states. The same with the human rights treaties, where you have one treaty and then one standing court. And the problem with investment is that you have 3,000 treaties going in all directions with little differences, and it's sometimes hard to know whether these differences should have legal consequences or not. And then you have all these ad hoc tribunals, and even if an arbitrator is reappointed, he or she might then be faced with a different treaty, so they cannot necessarily transpose. And also, I don't think it should be up to an individual to create a constant jurisprudence. So I think, in a way, the human rights courts have, well, I'm hesitant to say it's an easier job, because of course it's not. It's about many more cases than investment law, and many more cases than WTO law that these people are facing every day. But at least they have a more clearer structure.
Mm-hmm. Mm-hmm.
I would add a footnote that there's one specific aspect of the WTO context is that the consequences of an expansive view of attribution are not just the application of WTO disciplines in a larger range of cases, but also greater possibility of unilateral action against subsidies by individual states. And the rather restrictive approach that the appellate body at least began with in the China case on public body seems to me to reflect a hostility of the former appellate body and certainly of its secretariat towards these unilateral trade remedies, and and especially a suspicion that the U.S. is excessively using these remedies, countervailing duties, and that one of the main purposes of the WTO rules is to rein in that conduct. So it's this aspect of it may create some specific features in the WTO context that don't exist elsewhere, where the question is, how far should we go in enforcing the actual operational disciplines of say the human rights regime, as opposed to how strictly we should limit self-help conduct by an individual state.
Mm-hmm. Mm-hmm. There's a question has come from Sharon Holm about the recently released text of the EU-China Comprehensive Agreement on Investment. And one of the provisions in here, one commitment that China has made in this agreement, commits that SOE decision-making would only be based on commercial considerations. And that's a very interesting point, possibly related to, following up on some of these WTO complaints of the EU has raised. And the question asked then is, can you comment on the role of party committees in SOEs and whether these constitute direct or indirect control? And what are the implications for the commitment made by China? What mechanisms would ensure that the decision-making is based on commercial considerations? In other words, how can this even be made put into action? What specific factors should be set out in the treaty? Do potential attribution issues play out differently depending upon sectors? So that's a number of questions packed in there. The role of the party committees is, of course, incredibly difficult if you're looking for proof, because generally speaking, instructions via party committee are not going to be put in writing. And even if they were put in writing, they're not going to be made public. They're not going to be disclosed, and there's not going to be some discovery process by which you can get these in front of the tribunal. So what are your thoughts about the EU-China Comprehensive Agreement on Investment and its apparent attempts to head-on deal with some of these critiques of the Chinese SOEs?
I think it's a very good attempt. At least they're attempting, which is what virtually all other treaties do not. I do think it's quite enough. As you already mentioned, I mean, what's the penalty? That should be in the treaty. I think in many states, not just China, but in many states, instructions will indeed not be public. Even if you ask for them in a production of documents request, you might not get them, or you might simply be denied. Or you might be told that they don't exist, whereas you probably know that they do exist. I think in such cases, we should look a lot more at, for example, ownership, whether it's sort of whether the state owns the whole company or not, but also at issues, for example, who can appoint the board of managers? How many instructions, is the board of managers taking from the party committee? If you have a meeting of the shareholders, which consists of one representative of the state, and they have to say, give the okay on every decision above $1,000, then you have a state who's essentially running the business. I think it is possible to at least include a list of what is commercial activity, a non-exhaustive list, but that you give some guidance to these tribunals. And I don't really see why attribution should be different from sector to sector. As I said, I think I could potentially agree that sometimes, attribution in human rights should be different from attribution in trade or in investment. But if you mean different in the mining sector as compared to, the electricity sector, no. I don't see any reason to do that for any state. Again, what I say is not solely for China. I don't think we should focus only on China. I just did it because, the purpose of the occasion and because it's particularly important for China. But I don't think we should come up with an international rule book, particularly to regulate China.
And there's a question from Posheg Lee, and to whom I apologize. I hadn't seen it before, but we still fortunately have a minute or two to have Freya respond. And the question is, in the context of Chinese state enterprises, is there any way to deal with companies such as Huawei, which on paper are privately owned, but serve somehow strategically the interest of the party and which have a problematic relationship with the PLA?
Yes, that's a very topical question. I think it becomes, international law in general does not have any rules on what is property, for example. That is something that we leave to domestic law, and I would be a bit hesitant to start devising an international rule on that. I wasn't quite sure because I was taking notes that the second part on whether it was problematic if the SOE has a problematic relationship with the state that owns it.
As I understand the question, it's really whether in situations like Huawei, where there's evidence of government influence or at least significant potential for influence by the state and the party, this reality can be taken into account despite the ownership of the company being private. I think it really goes to the question of how much attribution depends upon the state owning the company as opposed to the state being involved in the company in other ways than through ownership rights.
Oh yeah, absolutely. I think that it becomes then more of an evidence issue if you can prove that there has been involvement, which of course is problematic. But I think that should count as heavily as ownership on paper. But again, with the party instructions, you might not be able to prove it. And I think for that purpose alone, it would be good that the treaty would already record some kind of indication of the things that can be taken into account, or the information that states should be willing to provide with regard to their relationship with their SOEs, for example.
Yeah, I agree completely. And I actually have stopped using in my own writing SOEs because by using that expression, one implies that the fundamental character of state enterprise is state, ownership. But the state might seek, private capitalization of a venture and still have an enormous influence on it. The real question is, given the nature of the primary obligations, is the state's involvement such that it seems normatively justified that the state should be held accountable for the behavior in question, which would violate the primary obligation if the state were acting in other more formal ways to achieve that that result.
So I'm afraid that we are going to have to call a close here because we have reached time and even run over a little bit. But this has been a fascinating discussion. I want to thank both participants, Professor Baetens and Professor House, for turning something that could have seemed somewhat abstruse and difficult into a very realistic and grounded discussion. And it reminds me, in a number of our talks this semester, we've touched on this question of behavior that has become very contested in international law, where China often comes to the fore, and it's not perhaps a unique actor, but it is acting on such a larger scale that it forces us to confront perhaps ambiguities and questions that previously could be ignored as being not so significant or not involving such large companies or such large actors. So thank you both very much, and thank everyone for participating, and we'll see you all next week.
Thanks very much. And it's been a real pleasure to engage with you, Freya, and I look forward to future exchanges in other contexts.
Absolutely. Thank you very much for both Catherine and Rob. I'm really grateful for your comments and for your time, and also to all participants.
Thanks a lot.
All right. Bye-bye.
Bye.
Bye.